Welcome to part 2 of a 3-part video series on the doctrine of removal and remand. In the first video, we looked at phase 1, which was the power phase. The power phase corresponds to the jurisdictional gate rule. The power phase addresses whether or not the court will have the ability to hear the case on removal. Phase 2, this video, we will discuss the procedure phase. And the procedure phase corresponds with the rule of roles and power. The procedure phase understands that the plaintiff is the master of the complaint, and only defendants have the ability to use the removal tool to remove a case from state court to federal court. Let's see what phase 2 says about what the particular procedures are to actually remove a case once it has been determined that the case is removable. Get it? Removable. Once it has been determined that the case is removable, this is how we do it. Once a defendant decides to exercise their right under 28 U.S.C. 1441 to remove the case from state court to federal court, they need a set of procedural instructions, right? Deadlines, documents, notice requirements. We find that procedural instruction in 28 U.S.C. 1446. Note, this is where most removal attempts fail. And they fail not on jurisdictional grounds, but they fail on procedural missteps. Before we get into the actual doctrine of the procedure of removal, let's take a moment to make sure that we are using the correct nomenclature when we speak about these different tools. A notice to remove is not a motion. A notice to remove is not a motion. I've set up a chart so that you can see the difference between a notice proceeding and a motion. A notice is meant to inform, where a motion is used to request. Right? A motion does not need a decision or a ruling from the court. A motion does. A notice is something that's usually required by a statute, like a notice to remove or a notice of appeal or a notice of deposition. So again, as we are working to ensure that we are as precise as we can be, we want to make sure that our terminology, our nomenclature is accurate. So what we are discussing in 28 U.S.C. 1446 is not a motion to remove. In fact, it is a notice of removal. Let's look at the actual statute. 28 U.S.C. 1446 addressing how to remove in subsection A. A defendant or defendants desiring to remove any civil action from a state court shall file in the district court a notice of removal signed pursuant Rule 11, containing a short and plain statement of the grounds for removal, together with a copy of all process, pleadings, and orders served upon each defendant. It sounds like a list because it's a list. What are the procedural steps to actually remove a case that has been deemed remove-able? First, the notice of removal must be signed pursuant Rule 11 of the Federal Rules of Civil Procedure. We'll come back to Rule 11. Once signed, the notice of removal is filed in federal court first. The notice of removal must contain a short and plain statement of the grounds for the removal. The notice of removal must have attached a copy of all process, all pleadings that are part of the state court claim, and a copy of the notice of removal with all attachments must be served upon all parties, including the state court clerk. Once the clerk of the state court that the case was filed in has received a copy of this notice of removal, the removal is now effective. So I pulled an actual case, the United States District Court for the District of New Mexico. It was filed October 2020. Looks like Robin G. Thornton on behalf of herself and others similarly situated. Sounds like a class action, similarly situated, right? But unnamed, right? Versus the Kroger Company Albertsons. And you might be familiar with the grocery store Albertsons, or you may be familiar with the grocery store Kroger, or you may be familiar with them all. Let's take a moment and look through this lawsuit. Now, if you look at the top of the notice, you'll see case 120 CV 01040 JBLF. That is the file stamp showing that the federal court has filed this notice. It's listed as document 1. It lists the date, and it says this is page 1 of 94. We're not going through 94 pages of this notice, but I do want you to make a note of that because we will come back to that 94 pages. What do we have? Well, we have a name of the document. The name is a joint notice of removal. I want to take you to the very first line because that's something worthy of being very excited about. Pursuant to 28 U.S.C. sections 1331, you know what that is, federal question jurisdiction. 1332, you know what that is, diversity jurisdiction. 1441, you know what that is our general removal statute. 1446, you know what that is what we're going over now, which is the procedure on removal. And 1453, we haven't talked about 1453. The reason I went through that is because your 10th week, 11th week in your first semester of law school, we can pull a live pleading, a real pleading, real people, real parties, real disputes, real court, and you know what the majority of that pleading is speaking on. That has to be transformative. Just wanted to take a minute to give you your flowers. Let's go ahead and move on to the next slide. There is a notice to the plaintiff provision, and that cites, we are doing this because we're told to under 28 U.S.C. 1446D. There is a notice that the removal is timely pursuant 28 U.S.C. B1. That's 28 U.S.C. B1. Put a pin in that. Put a pin in that because you're going to see as we get further down into 1446 that once we get to 1446 subsection B, there are actually two timing requirements. One is 1446 B1, which this one is filed pursuant, but another one is 1446B3. The difference, B1 is the timing structure that we follow if the removability of the case is on its face. So at the time of the filing, the case was removable. We're going to have a timeline that begins there. And if there was an amendment or some other paper that gets filed that makes what wasn't removable initially later removable, there's a timeline that we will follow there under 1446B3. But let's keep going. You see that we start to identify, pursuant to statute, the grounds for removal. You see that we start to identify, pursuant to statute, which statute? 28 USC 1446A. Remember, one of the 5 things is a short and plain statement of the grounds for removal. Well, see this notice? Grounds for removal. The court has jurisdiction pursuant CAFA. And what is CAFA? CAFA is a class action complaint. Class action complaint. And based upon CAFA, the court has federal court jurisdiction, right, as they identify in the notice. But this is what they mean when 1446A states that you must contain a short and plain statement for the grounds. We're not done. Another ground, you see why CAFA is the A ground. It's a class action suit. We have a B ground. There is sufficient diversity of citizenship. And we see the statute, 1332. We've got the statute, right? With the diversity of citizenship, not only are we looking at the diversity of the citizenship, right? But under diversity, we also must consider the amount in controversy. And so that is enclosed here as well. Well, let's keep going. Oh, look, there is another ground. What's the other ground? There's an allegation that there is a federal question in the lawsuit pursuant 28 USC 1331. So again, these are just examples of what 1446A says the procedure is. Okay, let's keep going. Let's get back to Rule 11, because one of the first requirements under 1446A is that the notice has to be filed pursuant Rule 11. What is Rule 11? On the left side of the slide, I give you Federal Rule Civil Procedure 11. It is entitled Signing Pleadings, Motions, and Other Papers, Representations to the Court and Sanctions. Put this in here because it's really important. When an attorney signs their signature, it means more than just their signature. It is a representation to the court, right? The attorney is representing to the court that a pleading or a written motion or whatever the paper is that is being signed or filed or submitted by that attorney, right? They are certifying to the best of their knowledge, to the best of their information, and the best of their belief, formed after an inquiry, reasonable under the circumstances, that what they are presenting is proper, is being presented for the proper purpose, that the legal contentions that are contained therein are warranted and not frivolous, and that the factual contentions will be supported by evidence. So when you look to the right, which is actually the signature page of that notice of removal and you see the attorney's name there, that is what is being represented by that attorney's signature. And if an attorney fails to live up to that, then Federal Rule of Civil Procedure 11C addresses general sanctions, motions and sanctions that may be entered on the court's own initiative. You don't ever want to be in that situation. Before we move from the slide, I want to point you to one more thing. If you look to the right, the actual signature block of the notice of filing, you will see Nathaniel Lampley Jr. pro hoc vice, application to be filed. What does that mean? That means that Attorney Lampley isn't licensed in the form that this case is pending in, but they will seek limited permission from the court to be able to practice in this jurisdiction without a license, right? But just for the limited purposes of this case. Procedure is the glue that sticks everything that we do together. Now, one more observation before we turn from the slide. If you look at the top, the signature page, which is generally the last page of the pleading, here the signature page is page 13 of 94. So what are the other 81 pages? It is the process, the pleadings, all the other papers that was filed in the state court proceeding up to the time of the notice of removal. Got it? Yeah? All right. Well, that was 28 USC 1446A. Now let's look at 28 USC 1446B. And here, instead of what does the notice look like? What does the notice contain therein? Does it have to be signed? Who does it go to? Where is it filed? Right? That's 1446A. We're now going to look at our timing element. We're now going to look at our timing element, and that's found under 1446B. Now, 28 USC 1446B contains two timing elements. These are two separate 30-day clocks. 1446B is one 30-day clock, and 14B3 is another but separate timing 30-day clock, right? 1446B1 applies when the initial pleading itself shows that the case is removable. The initial pleading shows that the case is removable. The defendant has 30 days from being served with the initial pleading, generally the complaint, right? Generally the complaint. They will have 30 days from the initial formal service of that pleading to file a notice of removal. For instance, if the complaint on its face states that there's a federal question, which means, because there's concurrent jurisdiction on a lot of matters between state courts and federal courts. What does that mean? That means that, yeah, I can file some federal question, right, in state court. I can file some diversity matters in state court, right? Concurrent jurisdiction. Yeah. If on its face that state court pleading establishes removability, that's 1331, 1332, my 30-day clock is going to begin from the date that I was served with that initial pleading. Got it? Now, 1446B3, no, I didn't skip two. Well, I'm not addressing two yet. I'm addressing the two 30-day separate clocks. So 1446B3 applies when the initial pleading did not make the case removable on its face, but the case became removable later. What do you mean later? I mean after the initial filing, right? The 30-day period starts when the defendant receives, for instance, an amended pleading that now makes the case removable, or a motion that now makes the case removable, or an order that now makes the case removable, or some other paper that now makes the case removable, like a discovery response, right? So if on its face the initial pleading shows that the case is removable, my time starts under 1446b1. If on its face the case doesn't appear to be removable, but becomes removable by some other paper, then 1446b3 is going to determine when or by when I would need to file a notice to remove. And that's going to be 30 days from whenever the defendant receives that other paper, right? 30 days from when the defendant receives the amended pleading, or 30 days from when the defendant receives the motion, or receives the order, or receives the discovery responses. Get it? Right? So say, for instance, on its face, the complaint is, let's say, we've got diversity of citizenship, but we don't meet the excess of $75,000. So on its face, when it's initially filed, it would not be removable under diversity, right? Well, then we do some discovery and I get the answers to the discovery responses, and the answer to the discovery responses now shows that the damages that are being sought are not less than that $75,000 threshold, but more than that $75,000 threshold. Whoa, it's now going to be removable based upon discovery. I've got 30 days from the date that I received that answer that shows that the case is now removable. Get it? All right. If not, stop the video, rewind, take your time. It's there. And I want to make sure it's there. So before we move to 1446B2, we're going to look at 1446B1 and B3 again. So 1446B1. Let's read it. The statute says, the notice of removal of a civil action or proceeding shall be filed within 30 days after the receipt by the defendant through service or otherwise a copy of the initial pleading setting forth the claim for relief upon which such action or proceeding is based, or within 30 days after service of the summons. Okay. The notice of removal of a civil action or proceeding shall be filed within 30 days after the receipt by the defendant through the service or otherwise of a copy of the initial pleading. That's saying that on its face is showing me that it's removable. Okay. 1446B, on the other hand, states that except as provided in subsection C, if the case stated by the initial pleading, look at this, is not removable, a notice of removal may be filed within 30 days after receipt by the defendant through service or otherwise of a copy of, look, an amended pleading, a motion, an order, or other paper from which it may first be ascertained that the case is one which has become removable. All right. So pay attention. Two different 30-day clocks. Two different 30-day clocks. One starts on the initial complaint, showing it's removable. The other starts when the initial complaint initially wasn't removable, having now become removable. Let's move to 1446b2, which is the unanimity rule. What are we addressing? Are we addressing time? Nope, that was 1446b1 and 3. Well, what are we addressing under b2? We are addressing who must join in the removal. Who must join in the removal? What do we have? B2A. When a civil action is removed solely under 1441A, all defendants who have been properly joined and served must consent to the removal. All defendants. In other words, all properly joined and served defendants must agree to remove the case. This prevents one defendant from unilaterally dragging the case into federal court when another defendant or other defendants don't want to be in federal court. This unanimity must be expressed either by signing the notice of removal, which would then be titled joint notice of removal, like our Kroger example a few slides back, or by written consent that's filed within the 30-day window. So who must join? All the defendants must join. Can it be implied? Nope. It has to be expressed. How is it expressed? It's either expressed through a joint notice of removal, or it's expressed by the other defendant or defendants signing a consent and filing that with the court within 30 days. Okay. What do we mean by properly joined and served? Properly joined and served. What does that mean? It does not mean that consent is required from defendants who have not been served yet, right? And it does not mean that the notice of removal has to be consented to by defendants who are not properly served. Okay, got it? All right, let's keep going. Let's move to B. Each defendant shall have 30 days after receipt by service on that defendant of the initial pleading or summons described in paragraph 1 to file the notice. So who must file? All the defendants who are properly served and joined. When must you file? Within 30 days after receipt. Within 30 days after receipt. This is what's important to know. Every defendant gets their own 30-day window to remove, right? And that's measured from when that particular defendant is served or receives the complaint, right? Make note, this replaces the old first served defendant rule, which unfairly forced later served defendant to remove within the first defendant's 30 days. I'll go over it again. Every defendant gets their own 30-day window to remove. And that window is measured from when that particular defendant is served or receives the complaint. Got it? Yeah? All right. Let's look at this later served defendant. What is that? Well, let's go to 1446B2C. If defendants are served at different times and a later served defendant files a notice of removal, any earlier served defendant may consent to the removal, even though the earlier served defendant did not previously initiate or consent to the removal. Wait. That seems like the earlier served now just got some additional time. Yeah. That silence was intentional. Let's look at slide 34 so that we can get an example of what 1446B2B looks like. Let's go to the next. There we go. Here's an example. Defendant 1 is served on January the 5th. Defendant 1 is served on January the 5th. Defendant 1's removal window will end on February 4. Defendant 2 was served on January 20. Defendant 2's 30-day window will end on February the 19th. Even though D1's time expires, D2 can still remove later, right? So these are independent clocks. Each starts at the time that they get served. These are independent clocks. Each starts at the time of service. Let's look at 1446B2C. Plaintiff sues defendant 1 and defendant 2. Let's see, defendant 1 served on January 5th, and defendant 1 doesn't remove. Defendant 2 is served on February 1. Defendant 2 files notice of removal February 15th. That's 14 days later, so clearly within the 30 days of their service. Under 1446B2C, D1, who had not removed and whose time is technically expired, may now consent to D2's removal. Got it? If not, rewind the video, look at the procedures, look at the cases. I promise you it will all come together. That was the rule of unanimity, right? And the later served defendant rule. Those rules serve three procedural purposes because they answer three procedural questions. One, who must agree to remove? 1446B, let's go back, 1446B2A. All of the defendants must agree, all of those who are properly joined and served at the time. How much time does each defendant have to remove? That's 1446B2B, 30 days after their service. What happens when defendants are served at different times? Each gets their own 30 days. And so if I have a later served defendant, the earlier served defendant who may have chosen not to remove can consent to the later serves defendant notice to remove. Got it? That's 1446B2. Excellent. Let's keep going. All right. We now get to 28 USC 1446C. 28 USC 1446C. And in your bones, you had to know that we would eventually get here because most of our rules have a what if this is a diversity case, right? Most of our rules have a diversity specific rule, and 28 USC 1446C will not disappoint. What is the diversity specific rule when it comes to timing of our notice of removal? 1446C1. A case may not be removed under subsection B3 on the basis of jurisdiction conferred by section 1332, that's diversity, more than 1 year after the commencement of the action, unless the district court finds that the plaintiff has acted in bad faith in order to prevent a defendant from removing the action. Ooh, that's some pretty nasty maneuver in there, right? 1446C, 1. A case may not be removed under subsection B3 on the basis of jurisdiction conferred by section 1332 more than 1 year after commencement of the action, unless the district court finds that the plaintiff has acted in bad faith in order to prevent a defendant from removing the action. This is called the 1 year bar, and it's a fairness rule. Congress wanted to stop late stage forum shopping. The only exception to this rule is bad faith. The only exception is bad faith. And the defendant bears the burden to show by a preponderance of the evidence that there was bad faith. So the defendant is required to show by a preponderance of the evidence the bad faith. So let's slow down and go through a step-by-step illustration. Get some scratch paper out so that you can work along with me on this one. You ready? Here we go. This is a diversity-specific rule. January 1, 2024, the plaintiff, a citizen of Louisiana, files a negligence suit in Louisiana state court against a defendant from Texas, right? So complete diversity between the parties. Louisiana is on the plaintiff side of the V, the versus, and Texas is on the defendant side of the V. The complaint specifically states that damages do not exceed $74,000. That stops my hope of removal based upon diversity. Right there on the face of the complaint, I cannot remove, right? So on the face of the complaint, if something comes up that allows me to remove, like an amended pleading or a motion or an order or other paper, get it? Get it? If I get something, now I couldn't seek the removal under B1. I'd have to seek the removal under B3. But right now, as it stands, I don't have grounds to seek a removal. Okay? The case proceeds in state court for over a year. Discovery moves slowly for whatever reason. Finally, on March the 15th, that's 14 months after the case was filed, plaintiffs update their medical records to show that the hospital expenses are now $120,000. So let's say that in my discovery, right, I finally get from plaintiff an affirmative statement that the damages that are going to be sought are going to exceed $75,000 plus fees and costs. Oh, this is other paper. Let me take you back to the language of the statute. Remember, B1 says 30 days within service of the initial pleading. That's if it's on his face, right? That's the initial pleading. 1446B3 is other paper. So if I couldn't do it under the initial pleading, right, but something happens later, like an amended pleading or a motion or an order or other paper, I've got 30 days from the time that I get this to seek a removal. Oh my goodness. So let's go back. It's been more than a year since this case has started, but I finally, after over a year, get some other paper. I get some answers to some admissions or some answers to some requests for production of documents, or I get some other paper that establishes for fact, not conjecture, but for fact, that the damages that I'm going to seek are going to exceed $75,000 plus my cost and interest. And I've got complete diversity of citizenship. Within 30 days, can I now file my notice to remove, right? Because I find out on March 15th that my expenses are going to be, that they're asking for is 120. April 1 is less than 30 days. I'm going to file my notice of removal. What happens? Let's go through it. Does my notice of removal make it, or is my notice of removal a break it? Step one. Here's your process. Was the case removable from the outset? 446B1 says you got 30 days from the receipt of the initial pleading if it was removable from the outset. Well, here, if I apply that rule at the outset, the complaint explicitly limited damages to $74,000 or less, which is below the excess of $75,000 threshold. So it was not removable when it was filed. So my conclusion is under 1446B1, I could not remove. Got it? Let's go to step two. Did later information make the case removable under 1446B3? I don't know. What's the rule? If the case was not initially removable, 1446B3 allows removal within 30 days after the defendant receives an amended pleading, motion, order, or other paper that first makes removability ascertainable, right? Let's apply that. On March 15th, the plaintiff updated medical records and revealed $120,000 in hospital expenses. That qualifies as other paper, right? So the defendant now is going to file a notice of removal on April 1st, which is only 17 days late, 17 days from the date that the defendant found out that the damages was going to more than meet the excess of $75,000 plus cost and fees, right? So what's the conclusion? I complied with 1446B3 and I filed my notice of removal. Da, da, da. I'm good, right? I'm done. Step three. What does 1446C1 say? A case may not be removed under B3, that's what I'm trying to do, on the basis of jurisdiction conferred by 1332 more than 1 year after the commencement of the action, unless the district court finds that the plaintiff acted in bad faith. Okay, let's apply it. This case began on January 1. The removal occurred on April 1. That's 14 months after the case was filed, which is more than 1 year. And there's nothing that we have that has established or that can establish by a preponderance of the evidence that the plaintiff acted in bad faith. So even though 1446b3 would allow me to remove, 1446c1 is going to bar that removal because it's a diversity case. Step 4. Did you see what happened? B1 is not being triggered because it was not initially removable on the initial complaint. B3, I'm good because I'm within 30 days of the other paper when I file my notice of removal. But my analysis doesn't stop there. I have to see if it's going to be excluded under diversity, which is 1446C1. And because it's a diversity case, I can't remove if it's more than a year from the date of filing in the absence of preponderance of the evidence proof that the plaintiff acted in bad faith. Final outcome, the case has got to be remanded to state court. It can't stay in federal court. While the updated medical records are valid, other paper under 1446b3, because the case is based upon diversity, I'm barred under 1446c1. I know. And we all cry. So how are we going to end our journey through 1446? This is how we're going to end it. 1446b1 is the initial 30-day clock, meaning that's the clock we go by if it was initially removable. 1446b3 is the later 30-day clock. That's my other paper clock, which means it wasn't initially removable, but some other paper has now made it removable. None of that matters with 1446c1 if the case is based upon diversity. So 1446b3 might open a window when I thought I was closed out, with 1446c1 slamming it shut. Can we end 1446? Because I was so very excited, right? Notice to adverse parties, that goes back to or reverts back to 1446A, where it says promptly after the filing of the notice of removal of a civil action, the defendant or defendants shall give written notice thereof to all adverse parties and shall file a copy with the notice with the clerk, right? Because it's that action, the filing with the notice of the clerk, that solidifies the removal. Hot dog. Now we know 1441, the power, the authority to remove, and we know 1446, the procedure of how to remove. But here's the reality that always finds its way in. Filing the notice of removal doesn't guarantee that the removed case is going to stay in federal court. 28 U.S.C. 1447 governs how the federal court evaluates cases that have been removed and determines whether or not the case will stay in federal court or whether the case will be remanded back to state court. And that is where we will end 28 U.S.C. section 1446. And that is where we will begin 28 U.S.C. 1447. And the third of 3 videos regarding the doctrine of removal and remand. I'll see you in the next video.